Good morning. My name is Matthew Kober. I'm an attorney with the law firm of Pearson Butler. Today I'm going to give a presentation on the changes in the landscape of personal injury litigation in Utah. Just as an overview of the presentation, I'm going to be talking about changes to the Utah Rules of Civil Procedure post-November 2011, additional disclosures required in personal injury litigation cases, a comparison of the three main options available in court, and what doctors and attorneys should be doing to prepare for these cases. The first section is changes in civil procedure rules. Civil procedure rules govern all aspects of litigation once a complaint has been filed. Part 5 of the Rules of Civil Procedure, Rules 26 through 37, govern what is commonly known as discovery. These cover depositions, interrogatories, requests for admissions, requests for production of documents, physical and mental exams, and those types of discovery procedures. Substantive changes were made to these rules in November of 2011, and I'm going to highlight a few of those, most of those changes. The Supreme Court made multiple changes that took effect November 1st, 2011. So any case filed after November 1st, 2011 will be subject to these rules. The purpose of the amendments, and I'm on slide 7 right now, the purpose of the amendments is to achieve the just, speedy, and inexpensive determination of every action by limiting parties to discovery that is proportional to the stakes of the litigation, curbing excessive expert discovery, and requiring the early disclosure of documents, witnesses, and evidence that a party intends to offer in its case in chief. There's I'm going to highlight 6 major changes. Those are proportionality, initial disclosures, the tier system, expert witness testimony, pretrial disclosures, and deadlines to respond to discovery requests. Starting with proportionality, there's a few factors that the court discussed, and this is a major change to the rules. Under the old rules, you could essentially request anything you wanted as long as it was relevant to the subject matter involved and not privileged. This turned out oftentimes to be a fishing expedition and could be quite burdensome. Under the new rules, what is allowed is evaluated under the Proportionality Rule, which is reviewed through multiple factors, which include reasonableness. They consider the needs of the case, the amount in controversy, complexity of the case, the parties' resources, the importance of the issues, and whether the discovery being sought is reasonable considering those factors. They consider the likely benefit. This looks at the benefit of the discovery at issue and is outweighed by the burden of the expense. The next factor for proportionality is consistency. This evaluates whether the discovery is consistent with the overall case management and will further speedy and inexpensive resolution of the case. Another factor is whether it is unreasonably cumulative or duplicative. And they also look at whether there's other sources where this discovery could be obtained. And finally, opportunity. This asks whether the party seeking the discovery has not had sufficient opportunity to obtain the information by discovery or otherwise, taking into account the party's relative access to the information. Looking at initial disclosures, the main change here is timing. Initial disclosures are now required by the plaintiff within 14 days after service of the first answer to the complaint, and by the defendant within 28 days after the plaintiff's first disclosure or after the defendant's appearance, whichever is later. So looking at this from a plaintiff's perspective, you need to have disclosures ready very quickly because you only have 14 days after the answer is filed. These new rules eliminate the need for case management orders, discovery plans, and attorney planning conferences, and these requirements were removed from the rules. Content is another major change. In addition to providing the names, addresses, and telephone numbers of individuals likely to have discoverable information, a party must now also provide the expected testimony of each fact witness that the party may call in its case in chief, except for an adverse party. Then there's also a change in production. The party producing the disclosures must actually produce copies of documents and other tangible things that a party may offer in its case in chief, except for charts, demonstrative exhibits, which fall under the pretrial disclosure rules. Now I'm going to talk about the new tier system. This is a major change to the civil procedure rules. The new rules establish 3 tiers of cases, and I'm on slide 18 right now. This is based on the damages pled at the time when a complaint is filed. There's 3 tiers that are established. Tier 1 is for cases from $0 to $50,000. Tier 2 is from $50,000 to $300,000, and Tier 3 is anything over $300,000. The selected tier determines the amount of discovery that is allowed by each party. This is actually a benefit, so cases that have less at stake have less opportunity for discovery and less opportunity for a party with deep pockets to try and burden the other party with oppressive or burdensome discovery tactics. And the timing that we're going to discuss is calculated from the date the first defendant's disclosure is due. Moving on to slide 20, this is a chart outlining the 3 tiers and the amount of discovery that is available per side. If you look at Tier 1, the interesting thing here is interrogatories. 0 interrogatories are allowed in cases of $50,000 or less. Total fact deposition hours, 3 hours. Rule 34 requests for production of documents, 5 requests. Rule 36 requests for admission, 5 requests. And the days to complete standard fact discovery, 120 days. So you need to stay on top of your timing to make sure that discovery doesn't go beyond those deadlines. You can look at the chart and see the relative amount of other types of discovery in Tier 2 and Tier 3. They increase proportionally depending on which tier you're on, taking into account the proportionality rules that we discussed earlier. The timing increases as well. You can review that slide. Moving on to expert witness testimony. Timing is the major distinction here. The party bearing the burden of proof on the issue for which expert testimony is offered shall provide the expert witness disclosure within 7 days after close of fact discovery. So you need to be marking on your calendars when fact discovery ends and be ready to make your expert witness disclosures. That's a very short timeline, and that timeline can lapse very quickly. Within 7 days thereafter, the party opposing the expert is allowed to make an election. They elect whether they are going to depose the expert witness or choose an expert witness report. If no election is made, then no further discovery of the expert shall be permitted. And then the deposition shall occur, or the report shall be provided within 28 days after the election is made. So again, you need to be prepared on whether you're going to choose to depose the expert or choose the expert report, and then be ready to take that deposition within 28 days if you choose deposition. Now the other side, the party not bearing the burden of proof, shall provide the expert witness disclosure within 7 days after the later of 2 options, the date on which the deposition or written report election was made, or on receipt of the written report or the taking of the expert's deposition. Within 7 days after that, the party opposing the expert may serve notice electing either a deposition of the expert pursuant or a written report pursuant to paragraph. Oops, that slide's not correct. We're going to need to change that. The deposition shall occur, or the report shall be provided within 20 days after the election is made. So just as a review, slide 25 is just a review slide on the timing of when expert discovery will occur, depending on the election that you make, whether you're going to take a deposition or whether you're going to elect to have an expert report. Now, talking about expert witnesses, certain disclosures regarding the expert witness are required under the new rules. Parties shall, without waiting for a discovery request, provide to the other parties information regarding any person who may be used at trial to present expert testimony. There's 4 main elements of information required to be disclosed immediately. These 4 elements are, number 1, the expert's name and qualifications. This includes a list of all publications authored within the preceding 10 years and a list of any other cases in which the expert has testified as an expert at trial or by deposition within the preceding 4 years. Number 2, a brief summary of the opinions to which the witness is expected to testify. Number 3, all data and other information that will be relied upon by the witness informing these opinions. And number 4, the compensation to be paid for the witness's study and testimony. So those are the expert witness disclosures. Now, there are a few differences in pretrial disclosures, which will come shortly prior to a trial that is scheduled. Again, without waiting for a discovery request, a party shall separately identify witnesses that the party will call and witnesses the party may call unless they're used for impeachment purposes. Likewise, charts and demonstrative exhibits must be produced at this time. The required disclosure shall be made at least 28 days prior to trial, and at least 14 days prior to trial, a party shall serve and file counter designations of deposition testimony, objections, and grounds for the objections to use for the use of a deposition and to the admissibility of exhibits. And there was one small change to the deadline to respond to a discovery request, and that changed to 28 days instead of 38 days. So when you're marking your calendar for responding to discovery requests, make sure and calculate 28 days. All right, I'm going to move on to the next section of the presentation. I'm on slide 32, and this is additional disclosures for cases that are specific to personal injury. There was a new subsection added under Rule 26 called Rule 26.2. Again, this rule is specific to personal injury actions, and these personal injury disclosures must be submitted in addition to the regular initial disclosures. There are required disclosures for both the plaintiff and the defendant. However, in this presentation, I'm going to merely review the plaintiff's obligations. So, the plaintiff's disclosures require a list of all healthcare providers who have treated or examined the plaintiff for the injury at issue, including the name, address, approximate dates of treatment, and a general description of the reason for the treatment. They're also required to submit a list of all other healthcare providers who have treated or examined the plaintiff for any reason in the 5 years prior to the event giving rise to the claim, including the name, address, approximate dates of treatment, and a general description of the reason for that treatment. So it's important to have that information available at the time you file your complaint, because getting that information from your client may prove difficult in that short a time period. You must also provide the plaintiff's Social Security number or Medicare Health Insurance Claim Number, the HICN, the full name and date of birth of the plaintiff. And then also you must provide a description of all disability or income replacement benefits received if the loss of wages or loss of earning capacity is claimed, including the amounts, payers' names, and address, and the duration of the benefits. So if you're going to claim lost wages, you need to make sure and have this information available. This could range from disability insurance, PIP benefits, etc. You also must provide a list of the plaintiff's employers for the 5 years preceding the event giving rise to the claim if loss of wage or loss of earning capacity is claimed, including the employer's name and address and plaintiff's job description, wage, and benefits, including the amounts, payer's name and address, and the duration of the benefits. You also must provide copies of all bills, statements, or receipts for medical care, prescriptions, or other out-of-pocket expenses incurred as a result of the injury at issue. Now, if the attorney has prepared a demand packet, which is customary, you should have all this information, but it's important to know that you have everything, including prescriptions and out-of-pocket expenses. If there were any investigative reports compiled, copies of all these reports prepared by any public official agency and in the possession of the plaintiff or counsel that describe the event giving the rights to claim must also be disclosed. And then you also must disclose copies of all written or recorded statements of individuals in the possession of the plaintiff or counsel regarding the event giving rise to the claim or the nature or extent of the injury. I'm going to move on now to the next section. I'm on slide 39, which is a comparison of 3 court options. And this is taking into account the new tier system that I discussed earlier. So we're going to go over briefly the 3 options for filing a complaint. There are regular district court with the 3-tier system, what are called 321 arbitrations, and small claims court. Starting with the district court system, which is just regular court, filing in district court, I'm going to go over a few benefits and pros and cons of each of these systems. The benefits of district court are there's an expedited resolution for smaller value cases through the tier system. There's less ability for deep pocket defendants to bury you in paperwork and discovery, or vice versa. And the court will help intervene to determine proportionality rules. And in fact, some of the courts have local rules in helping resolve any discovery issues. Make sure and review local discovery rules if you're in different districts other than 3rd District. There's also the ability to obtain judgments against the personal assets of the defendant, which is not available in some of the other systems. You can seek excess verdicts, which is when you get a verdict larger than the insurance policy available, and you can recover beyond those limits. You can include property damage claims in cases filed in district court. You can include punitive damages. This is especially relevant for DUI or drug cases where those are allowed. And then both jury and bench trials are available in district court. Some of the downsides of district court include you waive any right to higher verdicts through the tier system unless you amend your pleadings prior to trial. So, for example, if you elect Tier 1, which is up to a maximum of $50,000, and you receive a judgment of $100,000, you will have waived your claim to the other $50,000 unless you amended your pleadings prior to the amending pleadings deadline. Here in district court, there's no automatic right to appeal or for a trial de novo. Trial de novo is when you start over and have a new trial without any regard to what happened in the prior trial. There's no right to additional attorney's fees under certain conditions or circumstances. And this will likely take longer than 321 arbitrations or small claims cases, especially in Tier 2 or Tier 3 cases. That's a review of the district court. I'm going to now review some pros and cons of what are called 321 arbitrations. I'm on slide 43 if anyone's following along. These are called 321 ARBs because they come from the Utah Code annotated 31A-22-321 if you want to review that statute. And these are designated for use of arbitration in third-party motor vehicle accident cases. If you're not familiar with arbitrations, arbitration is a form of alternative dispute resolution, or ADR. It's a legal technique for the resolution of disputes outside of the courts, where the parties agree to refer the matter to one or more persons called arbitrators who decide the outcome of the case. It's like mediation, if you're familiar with that, except for there is a binding decision at the end of the case. How 321 arbitrations work is similar to a district court filing in the beginning. You file a complaint as if you were going to regular district court. And at that time, the plaintiff has the option to elect and make an election of going to arbitration, and that election will be made within 14 days of filing the complaint, and then the plaintiff has the option to rescind that election within 90 days. Now, if you do rescind, you cannot re-elect arbitration, so you do need to make sure that if you're going to rescind your election, that it is something that you want to do. Unless otherwise agreed by the parties, a 321 arbitration is done by a single arbitrator. If the parties cannot agree, there is a mechanism where each side picks one arbitrator, and then those two arbitrators will pick a third arbitrator, and then each side pays for an equal share of the arbitrator's fee, whether there's one or whether there's three. Dispositive motions, if there are any that want to be filed during a 321 arbitration, these will actually be heard by the district court and not by the arbitrator. And it is important to note that 321 arbitrations are only for cases less than $50,000. Now, we talked a little bit about a trial de novo earlier. In the context of a 321 arbitration, if the plaintiff, if the arbitration goes to judgment or verdict, and the plaintiff seeks a trial de novo, meaning you don't agree with the outcome and you want a second bite at the apple, and you've moved to district court, the plaintiff must obtain at least $5,000, which means you cannot come out with a goose egg with zero, and the verdict must be 30% greater than the arbitration award, or the plaintiff will be responsible for the other side's costs. And those include the costs identified in Rule 54D, if you want to review that rule, as well as costs of expert witnesses and depositions. And those costs are awarded up to $6,000. Now, if the court finds that an appeal was made in bad faith, all attorney's fees are allowed to the non-moving party. So if you do want to seek a trial de novo, make sure and review these conditions to make sure that you feel comfortable you're going to meet those requirements. Now, if the defendant seeks a trial de novo, if the arbitration award is made and the defendant believes that it was too high, the defendant must obtain a verdict at least 30% less or the same result as the plaintiff. And then there's actually a little bit distinction for when the defendant seeks a trial de novo. The judgment can go up to $65,000 instead of $50,000. Now, some of the benefits of 321 arbitrations include an expedited resolution for smaller value cases. You can rescind the election to arbitrate within 90 days. The claim is for new money, meaning that doesn't include any PIP payments that were made. You can still pursue uninsured motorist claims afterwards if you exhaust the full policy limit. You can seek a trial de novo if you don't like the outcome. Again, you must get at least 30% more. You have the ability to recover expenses up to $6,000 if the defense does not obtain a verdict of 30% less than the award, and attorney's fees if defense seeks trial de novo in bad faith. You're able to pursue cases, and another benefit is you're able to pursue cases larger than $10,000, which is the small claims threshold, without having to go into district court if you don't want to. Some of the downsides of 321 arbitrations, and I'm on slide 52 if you're following along, include the rules of civil procedure and evidence still apply. So you're still bound by those rules. Property damage claims are not allowed in 321 arbitrations unless agreed upon by both parties. Punitive damages are not allowed, so if you want to seek punitive damages, 321 arbitration is not a good forum for you. Again, the 321 arbitrations are limited to cases under $50,000. You cannot obtain a judgment against the personal assets of the defendant. Your recovery is limited to the insurance policies available, and you have to pay for an arbitrator fee on top of the filing fee for the complaint. So there's a little bit extra expense with the arbitrator. Moving on to small claims court, small claims is available for cases less than $10,000. That's the maximum benefit you can get out of small claims. One benefit of small claims is they have their own simplified rules of procedure, and which apply here in small claims court. You have a very quick adjudication, so if you have a case that you think is going to settle for less than $10,000, you can get in and out of small claims very quickly. And actually there's a growing use of small claims to resolve some of these types of cases. I included a couple examples here. One of the most interesting cases that has been going around the country was this lady named Heather Peters sued Honda Motor Company, a large corporation, in small claims court for misleading her regarding fuel economy. This was done to opt out of a class action lawsuit where she probably would not have gotten much even if they won after years of litigation. She originally obtained a judgment in small claims for a little over $9,800, and this was considered a great victory because this was a quick and easy judgment against a large corporation who surely would have buried her in paperwork in regular court. Unfortunately, this is a fairly recent case. The verdict was overturned, but it did get a lot of attention for the use of small claims court for these types of cases. And we don't know what the final outcome of that case is going to be at this time. Another example was a couple sued an airline for making them sit apart on a flight. They sued for the cost of the first class seats, and interestingly, no one from the airline even showed up, and they got a judgment for $4,300 plus court expenses. So that was an easy, quick and easy resolution of their claim. Some of the benefits of small claims courts include a very expedited hearing claims. Clients in small claim cases are able to be represented by attorneys. That is a misconception by a lot of people that you are not allowed to have attorneys in small claims, but that is allowed but not required. The rules of civil procedure and rules of evidence are not applicable here, and there's a very easy format to present your evidence before a judge without having to follow formal rules. Some other benefits of small claims include you have an automatic right of appeal without requiring a larger verdict. So if you don't like the outcome in small claims, you have an automatic right of appeal to go into district court without any consequence for not meeting a certain threshold of improvement on the verdict. Here in small claims you can get a judgment against personal assets of the defendant, unlike the 321 arbitration. You're not required to accept insurance limits as the recovery, as the sole source of recovery. And most small claims, especially in 3rd District, are handled at night. And so if you have a tight schedule during the day, you can do that at night and not bog down your calendar during the day. And in small claims, sometimes they have on-site mediation services where you're able to resolve your case through mediation without any extra cost just by showing up to the small claims hearing. Now, some of the downside of small claims courts include, again, the maximum limit is $10,000, so you need to evaluate the estimated value of your case before deciding going into small claims. Either side can appeal here without any consequence, and so if you go and get a landslide verdict, expect appeal from the defense. The defense can appeal without any requirement to obtain a 30% less verdict, as in the 321 arbitration. Now, there's no attorney's fees awarded for failure to obtain a smaller verdict on appeal at trial de novo. And the court can only award money damages, whereas in district court you may have issues where you want to seek equitable or injunctive relief or award of property. So if you are seeking any of those options, small claims court would not be a good pick for you. So the last, moving on, I'm on slide 60 here. I'm going to just go over a few points that we addressed through the presentation, which is just what doctors and attorneys should do to prepare for some of these changes under the new rules. Number one, evaluate your damages. Especially in regular court where you're going to have to elect a tier 1, 2, or 3, you need to know what you believe your case to be worth. If you elect option 1 for having some of the less restrictive discovery limits and it's a borderline, you could end up with a judgment and lose some of that judgment amount by waiver. So it's important that you know the value of your case before establishing a tier. When you file a complaint, you do need to establish which tier you're electing. Under the general rules of pleading, a party who claims damages but does not plead an amount shall plead that their damages are such as to qualify for a specified tier defined by Rule 26C3. So review that rule before you draft and file your complaint. Again, a pleading that qualifies for Tier 1 or 2 shall constitute a waiver of any right to recovery of damages above the tier limits specified in those rules. Next point, know what experts you want to use. There's very quick timelines for making those elections, whether you want to depose them, whether you want an expert report, disclosing what expert you want to use, what expert qualifications you have. So make sure you understand those issues before you file your complaint. Be ready to make the election on whether you want to depose or elect the report. And make sure and talk to your expert and have that expert ready for deposition. Doctors and surgeons and physicians, their schedules can get tied up very easily and their available time can be out in the future. So make sure that you coordinate with your expert witness and make sure they're available for the deposition within the 28 days. One thing that will help some of these issues is by modifying your intake questionnaire. From the very beginning, if you can get some of this information from your client, that will help you if you filed your complaint, you're up against a deadline, you need to get some information from your client. They may not have a list of their 5 years employers or 5 years medical history ready at their fingertips. If you've had them fill that out at the very beginning in your intake questionnaire, you'll have that information available that's required in your initial disclosures. For the expert must have information available for the plaintiff attorney ready for these disclosures within listing the 4 elements of disclosure: the qualifications, the list of publications, list of other cases, and the cases they've testified as an expert. And then the expert needs to establish the rate, the amount that they're going to be paid for their expert testimony, because that does need to be disclosed. This might be a little bit technical, but doctors can be picky about this. If a doctor wants an attorney, one of the elements of disclosure is listing a description for the reason of treatment. If the doctor is specific about this, then they should submit a description for the reason of treatment to the plaintiff attorney to be included in the initial disclosures. Basically, you just need to have your ducks in a row. Before, there was a lot of leeway. File your complaint, get in court, get things started, and figure things out afterwards. Now, you've got very short timelines. Before you file your complaint, make sure you understand these rules, know what you need to have prepared, and get that information. If you're seeking some medical records, sometimes those medical records requests can take up to 30 days or even longer, and you may miss a deadline just simply by not having those records requested before you file your complaint. Doctors need to prepare their CV detailing their qualifications, the list of publications in the last 10 years, have the expert's name and qualifications, list of publications, we talked about that, within the preceding 10 years, and a list of cases. That can be burdensome if you're trying to go back and get the case numbers, the case names. No one really remembers specific case names. They just know what case they worked on. So for a doctor, have that information available for the plaintiff attorney. On slide 66, we're at the end of the presentation here. We reviewed changes in the landscape of personal injury litigation. The very last slide is simply a slide about me. I'm a graduate of the University of Utah Law School. I attended BYU for undergraduate degree. I like to say I bleed purple. I can root for either team depending on who's winning. I'm one of only 4 attorneys right now that are certified in motor vehicle occupant injuries by the Personal Injury Training Institute. I'm also recognized as a top 40 under 40 by the National Trial Lawyers. I've handled cases ranging anywhere from $3,000 to $3 million, and I've handled cases ranging from auto accidents, dog bites, premise liability, wrongful death, brain injuries, hearing loss, surgical cases, aviation accidents, etc. So if you have any questions about these rules or any other type of cases, feel free to give me a call and I'll be happy to talk to you. Thanks.